Good morning, and thanks for joining us here on Condo Solutions. It's Monday morning, so this is Condo Solutions, 9 to 10 o'clock. We answer your questions about condo law, about condo issues, homeowners issues, those types of things. Some of the questions relative to co-ops, maybe some timeshares, all of that. We're here to help you out. It is a call-in show. You can give us a call, and we'll get you on the air with your question. The number is 772-220-9788. That's 220-WSTU or 220-9788 is the number in the studio. And if you write that number down and hold on to it, you'll be able to call in to all of the shows here on WSTU because they do have that number. And many of them are call-in shows, and you can ask questions or make a comment. For our program here, we have only a very few guidelines or rules, one of which is that when you do call in, we need a name, but we don't need your association name because from time to time, we're going to try to answer your question, but we're also going to try to answer a broader series of questions. And sometimes if you give us your association, people may have a similar problem, might tune out. So we encourage you to just give us a name that we call you. It doesn't even have to be your name because Evan doesn't keep track. So we don't know for sure who it is, but we do try to help, and we will try to give you the information. The other thing that we always caution is that we give what we call radio answers. That's what that means, is that we make the stuff up. No, it means that we give you an answer based on court cases and on the law and regulations, but we don't have your documents, so we can't give you a hard and fast answer. So if you've got something you're going to court on, you should have somebody like our fantastic attorney, Peter Mullengarden. You should sit down with him and go over those regulations and go over those documents and see what if maybe your situation is the same, or maybe there's some twist in it because your documents are a little bit different and they have language in them that might change things. So again, that's the only caveat we have, is that if you're planning on taking this to court, you can't do it based on what we're doing because we don't have your documents, but we'll give you an answer based on your interpretation of the documents and on some of the common practices. And also at the same time, we may talk a little bit broader about your problem, so that if somebody's got a similar but not exactly the same situation, because maybe their documents are a little different or whatever, that will help give you a better or give them an answer too. So those are the only rules and regulations that we have. Good morning, Peter. How are you this morning?
Morning. I'm well, Mark. How are you?
I'm doing good. Wasn't so good when Tennessee beat Florida in basketball. I can't figure that basketball team out. They beat the team by 30 points the week before, and then they lose. So I just don't know. But anyway, other than that, I'm kind of excited that we actually are going to have a March Madness. It should be, hopefully we are. It's going to be kind of fun this year. That's always my favorite time of the year is the March Madness. So it should be exciting, and that I'm looking forward to that.
That's right. We're still the defending champions.
That's right.
Virginia.
That's right.
2 years running.
That's all we need. That's the only way Virginia was going to win a national championship was.
Wait a second.
But anyway, so the ACC is a little weak this year, but
They are weak.
Yeah, but Miami's got not a bad team, and of course FSU. They've got the same team. They're the top team in the country until they actually play somebody, and then they drop off the table. But anyway, so we have our first caller this morning, John. How are you this morning, John?
Good morning, gentlemen. Always a pleasure. I have a question regarding contracts. Now, this is just generally speaking in lieu of our documents. I'm not going to say could or can, but should a president of an association, an HOA, sign a contract without the board reviewing it and approving it?
Only if he's been delegated that authority specifically previously. In other words, if the board had delegated to him in a resolution that the president had the authority to negotiate and sign a contract. Other than that, I'd say no.
Because this association is like 15, 16 years old, so I would not be able to know that or not. If it's specifically not in the documents, would that pretty much make it clear not to do it?
Well, this is something, I mean, that is a good question. You could, look at the, most bylaws do have the functions and duties and powers of the various officers. But generally speaking, and as Mark says, we always speak on the show somewhat in generalities, but generally speaking, the corporation is run by the board. Okay. And the officers have certain duties, usually certain ministerial duties, but they have certain duties. Typically, the president, the best analogy I can make is the president is like the chief executive officer. The president pretty much is there to make sure that the policies and the resolutions of the association are carried out. But generally speaking, the board, because the board runs the corporation and makes the substantive decisions, the board would approve a contract, then the president, in his function, would sign the contract on behalf of the association. But generally, the president doesn't have the executive power to unilaterally approve a contract and sign it. That's a board job, not a president job.
But I will.
Yeah, I agree, because if I was president, I don't think I'd want to take that on. Well, but unfortunately, we have a president who has done this in the past. They were actually removed from being president, not from the board before, because of, taking higher authority that they were granted. But I had another question, if you don't mind.
Well, let me just, before we get off that.
Sorry, go ahead, Mark.
Yeah, I just wanted to mention a couple things on this. One, and Peter touched on it, but so that there's a question of do you have a delegated authority? And there are very few situations where the board in a condo or HOA is going to delegate the authority to determine a lot of the contracts. In other words, to actually negotiate them, determine what you're going to pay and how you're going to pay them and all that kind of stuff, and what the terms are going to be. As Peter mentioned, that's usually left to the board. But there are some situations where, and in some arrangements where the that authority is delegated. But the problem you've got is that, as Peter mentioned, there's usually a discussion in your documents relative to the position of president, vice president, secretary, treasurer, and what authorities that they have. And then along with that, unless that specifically says they don't have the authority, they have an apparent authority to sign those documents. So even if they didn't have the authority to sign a document, potentially the party that they're signing the contract with would potentially be able to hold you to that contract because of an apparent authority that a president would have in signing a contract. And so
that is correct. Yes. And that's a separate issue, but good point.
Yeah.
Where, yes, the other party could, because that president had the apparent authority, to then rely on that authority in enforcing the contract.
So you have to be kind of careful. Go ahead.
Here's the scenario. We were shopping around for new management companies, and the president made together a little diagram of all the companies, and they voted on who they thought they should go with. Well, that's just who you decide to go with. We didn't see any contracts because we didn't get that far. We just decided, the preliminary information. So if it turns out that this contract has been signed, to me, that the board not even looking at a contract is really going out on a limb. Like I said, if I was president, I don't think I'd want to do that. I think I'd want the board to look at the contract, agree to the contract before anybody signs anything.
Oh, of course. Yeah. I mean, definitely what should have happened in that scenario is that company was chosen, and then the contract would be presented to the board, all the board members, for their review and for their comment.
Mm-hmm. Now, my other question was the members of a HOA. Do they have a right to a members list? Everyone who is a member in that community, their name and address.
Yes, that's part of the official records.
I'm sorry?
That's part of the official records that any owner is entitled to.
Good. And with, when they have elections, two people live in the same house. They both own husband and wife, usually is the scenario. but only one can vote per unit per lot, whatever you want to call it in your docs. Is it a requirement in the statutes that they fill out a voter certificate?
No, it's not in the statute. That is a individual association by association issue, usually addressed in the articles of incorporation or the bylaws, occasionally in the declaration, but usually it's the articles of incorporation or the bylaws, typically more often than not the bylaws. And some associations have a voting certificate requirement and some don't. Some just say that if it's multiple owners, like whether that's a husband and wife or two brothers or whoever, some documents just say that any owner can sign. Any owner can vote. Others require, as you said, the designation of a voting representative or a voting member. Again, that's a case by case basis.
Yeah, because it's interesting. We just had an election, and then we had a national election, and even on a micro scale, it's amazing how many people really weren't allowed to vote that voted, because there was two parties that lived in the same house, but they didn't have the same last name. They weren't married, but they both owned the property, and ballots are coming in because people weren't paying attention to them. But with a proper list, of course, you'd be checking off each address. But apparently, some things got slipped by, and then we had a petition. And we found out on the petition that a lot of the renters, not even the owners, were signing on the petition. So nobody was even, and the kids, they'd have like four people, a husband and wife and two kids. So they have four people sign for one address, just to beef it up, to make the petition look like a wonderful number. They got like over 100 names, but if you really dug into it, it was only 50 homes. And, to me, it's just amazing, on a micro level, how difficult it is for even the supervisor elections to keep track of all this stuff. But I was just curious because, voter certificates, like you say, I've never seen in the statutes, and it does vary from community to community. And we have in our post-it, it's not a gated community, but when you drive in, it says no solicitation. And then there was the argument, well, does that apply to the members, or does it just apply to the people driving in? Because if it applies to the members, how can you go around and knock on doors for a petition? So have you ever run across that before?
Well, that depends how you determine the word solicitation. I mean, is that a commercial solicitation? Is it internal political? I don't know. I guess, since owners do have a right, presumably, I mean, in the statute, there are certain things that can be done by petition, and in the documents, there are certain things that can be done by petition. So I don't think you can say in your documents you're allowed to submit a petition or submit something like that to request a membership meeting or to request that an item be addressed on the board, and then say you can't do it because it's no solicitation. I mean, that's just not going to fly. Your documents allow it, and you can't say that you have a rule that says that you can't do it. So I think that type of thing, an exercise of your right under your documents to petition the board or to petition the association, I think they have a right to do that, notwithstanding any kind of board rule that says no solicitation.
Yeah, you bring up an excellent point, because in the Condo 718, if someone wants to put something on the agenda, they got to get 20%, and that's in the statute. So correct. I can't see where a condo association can overrule that. Or if you want to, let's say, remove a member of the board, and you don't even have to show cause, you can just remove them if you get enough petitions together. I can't remember what the threshold is, if it's 50 plus 1 or 2/3. But again, even if your docs say you can't go around and knock on doors, I mean, if the statute says that you can remove someone via a petition, I don't see how the board or any association could deny people from knocking on doors.
Right. Your documents cannot create a waiver of someone's statutory right. Okay.
Yes.
So that would not be enforceable.
Mm-hmm. And here's one last thing. A person's name, Mrs. Smith, has a trust, and on there, she has, in the trust, she has a different person as the trustee. Does that make that trustee person an owner of the property because he has the right to run the trust, so to say?
Yeah, the trustee really does have I believe it's the legal title to the property. I'm not the trust and estates guru, but yeah, the trustee basically does have. I
Well,
would say,
basically, what happens is that the trust
oh,
document itself, the trust document itself is, or the trust itself is a legal entity once it's become irrevocable. And whoever's the trustee of the trust, it has the authority to execute documents and to vote or do whatever. And that individual is, it's kind of like if you had a corporate entity that owned, the president would have the authority to act upon the corporation. With a trust, the trustee has the authority to act upon the designation.
Yeah, I don't want to. I didn't want to, like Peter says. I didn't. You guys aren't trust experts, but in this case, I'm wondering if an irrevocable trust, you can designate a trustee, and if that person then would be able to run for the board. That's what I'm getting at.
Well, if it's the owner, and depending upon what your documents say, usually the owners have provision for corporate, for corporate owner members. Whether or not a corporation, an owner has a right to appoint have a member run for office. So therefore, if you've got a corporate owner, they would have the authority. A corporation has to have an officer act on its behalf. So same thing with a trust.
But in this case,
same thing with a trust.
Be a trust, because a lot of people just want to put it in trust to avoid probate.
Yeah,
and just let it
but
go.
There's a lot of times, actually, in particularly with irrevocable trusts, you have a lot of situations where the purpose is beyond just the probate issue. It's also, for example, a lot of times you'll take a property and especially an expensive property, and you'll transfer it through the trust to beneficiaries, but you give the person that originally owned it, the spouse or the husband or whatever, you give them a life estate. So they have the authority to control the property and to utilize it while they're alive, but they don't have the authority. They may not have the authority to sell it or, to do something with it. So,
but the key word is irrevocable. I'm talking about a revocable trust. So most of these, when you look them up, are revocable trusts that people put on their deeds. And even with a life use, let's say it's a revocable trust with a life use, that life use doesn't make the person a member. Now, if it was irrevocable, yes, I'd agree with you. I'm not an attorney.
Well,
but I'd agree with you if it's irrevocable.
Revocable trusts are what they call grantor trusts. They have, they really are just, they have no legal protection from liability. They are strictly pass-through entities that the activity is. And typically, you don't even file a tax return for a grantor trust. It's just all it does is just files. You file it on your personal tax return. So it's kind of it's an entity, but that entity doesn't really have legal status from the standpoint of protection and activity until such time as it becomes irrevocable. So a revocable trust can become irrevocable upon the death or disability, typically, of the party who establishes the trust. Once that person is incapacitated, then that trust can become irrevocable at that point.
Because we had a board member who was not on the deed, but they said, well, we have a trust and they're in the trust, and that gave them the right to be on the board. Well, I kind of thought this out in my head, and I'm like, well, I can only think of maybe an irrevocable trust and the person is the trustee, but I can't think of a revocable trust where that would happen.
Well, no,
but I don't want to get in the woods here. I was just trying to bring this up because of that situation we had once where someone was on the board, but they weren't on the deed.
Yeah. That's in those situations, that's going to be a case that whoever has control of the trust, not necessarily the beneficiary, but whoever has control of the trust is probably going to be the one that has the authority to be on the board and to vote. They're the ones that would have the legal capacity to take to be on. But so you'd have to look at that. But sometimes those documents allow you to appoint somebody too. So Anyway,
Well, thanks for answering all the wonky questions. Sorry.
no problem.
But I appreciate the show. God bless you guys.
Thanks. Thank you.
Thank you.
And for any of you out there that have questions, feel free to call 220-9788, 220-WSTU. One thing I want to mention, going back to contracts, Peter, and you and I have talked about it before, and I kind of wanted to talk about it because it's an area that we usually give different answers on to some degree, and because of the way we come at problems sometimes, and the way the attorneys versus the way attorneys versus CPAs sometimes come at problems.
What are you trying to say here, Mark?
Well, what I was talking about is this question of whether it's a good idea to have your attorney look at a contract, and because we didn't really talk about that. We talked about the board and all of those kind of things, but one of the things we didn't talk about is that there is a need to have your attorney look at those contracts. And so in the example we were talking about, they were talking about a management contract with a property management company. I would definitely have my attorney look at that document. If I'm a board, that's where I'm going to spend a little bit of money and get my legal counsel in to look at that property management contract to make sure that the association's rights are protected, to make sure that in case the relationship goes sour, that you're going to get your documents back, how you're going to get those documents back, and what kind of protections the association has to get out of the contract if what's going to be considered a default. How am I bound more than 30 days? Is it 9? What's the practical aspects of that contract? So I didn't want to, I wanted to mention that's there are some contracts. The other thing is typically construction contracts. When you're doing any kind of significant construction project, not only should the board approve it, but your legal counsel should look at that and make sure that you've got all of the protections, including insurance and everything else that you need in those things. So that's one thing we didn't talk about, is that, and I know it's because you don't, Peter, you don't usually push, those issues from your own standpoint. Look, it kind of seems self-serving, and I just wanted to make the comment that those are documents. Those are things that you should call in legal counsel, even if you've got an attorney that's on your board that's retired from New York or Connecticut or whatever. First of all, they may not have practiced in that area of the law. They definitely don't know Florida real estate. They probably have no idea on Florida condo and HOA law and all of those kind of things, and Florida construction law, and lien law. So it's always a good idea to spend the money. Now, here's the area that you and I probably don't, is not every contract needs to go to your attorney, though. I don't believe. I think that there's, a time when, if we're talking about a $3,000 contract or a $2,000 contract, and it's got, it's a relatively short duration, that you can get out of, then it may be that, you've got people on your board who feel comfortable reviewing those kind of contracts, and can, you may not need to go to the board on something like that, particularly if the cost of, or the attorney, particularly if the cost of doing that is going to be just about as much as the contract. That's the point I was making. In some cases, you have to look at, what's my risk here, and if my risk is less than or equal to what it would cost me to have it reviewed or rewritten, then maybe I just let it go. So I was just throwing that out there, Peter. That's kind of I wanted to make sure we were bringing the attorneys in on some of this stuff too, because sometimes we don't, because we have board members, they say, well, I can do that. I know how to do that. It's not always a good idea.
No, I agree. I mean, without, like I said, sounding too much self-serving here, I think it is a good idea. I mean, I just recently reviewed a management contract, and one of the things that was not in it was the ability for the association to terminate it on a certain amount of days' notice without cause. And I think that's very important and it's just one issue, but I think that's very important for any service contract, whether it's a management contract, a landscape contract, pool contract, whatever, all these service contracts. You want the ability from the association standpoint to be able to terminate it quickly on a certain amount of notice, relatively quickly, without getting involved in having to prove a breach or prove a default, and then they dispute it. And I'd rather have a quick divorce than a messy, expensive divorce.
Right.
So that's just one issue. Now, that's not so easy or not always possible to construct a contract, but that's just a matter of negotiation. And there's certain contracts or certain service contracts where it's also very, very difficult, like a cable TV contract or something like that. The cable providers usually aren't too interested in allowing association to terminate without cause.
Right.
But otherwise, for those, so that's just one issue. I'm just saying that that's the only issue, but that is an important issue because I think and I've mentioned this on the air before, so I apologize to those who I'm repeating this, but sometimes I find my clients have this misperception, and I'm not speaking of everyone, of course, that contracts can just be terminated when you're tired of it or when you just want to make a change. You just terminate them, and that's just not true. Contracts are only terminable by their provisions, and if it contains a termination provision without cause or whatever, you can do it. If it doesn't, you can't, unless there's some statute that allows you to do it for that particular type of contract. So I find that over and over and over again, I don't know where it comes from, that this perception is, you just send out a 30-day notice and you'd be able to walk from a contract. And there's nothing in the law that says that. Again, unless it's some kind of specific contract that some specific statute, provides for that. So again, I'm not going to harp on this too much more, but since you mentioned it, that is an important issue. That again, for those kind of service contracts that you want to have in there.
Yeah, and there's a couple things too that, like, since we're talking about property management, situations, there's a couple things in there too that I know constantly come up in these situations. So even if you can terminate, even if you can terminate the contract, and you need to make sure that there are very clear provisions in the contract relative to what the property manager is going to provide you with when the contract is terminated.
Well, actually, there is a regulation on that too. I mean, it's in the Florida Administrative Code. It's under I think it's the manager code of ethics, the manager code of responsibility, where they have to turn over everything and they can't withhold it. Basically all the property of the association. But you're right, and it should be in the contract. But there is and
what I'm getting at is how they turn it over. For example, if I'm using Tops or QuickBooks, and I have everything you've got on electronic file, well, I'm not required to turn over the electronic file. So even if you're going to have QuickBooks or you're going to have Tops, I may not necessarily have to provide you with file. I can provide you with paper. I can give you all of the documents. I can print out the general ledger. I can print out the accounts receivable. I can print out everything you've got, everything that's there. That's going to take you a long, long time and disrupt your activities, particularly, if that's at the middle of the year. Now you're going to have two sets of records. If you're trying to find something that happened at the beginning of the year, you go into one system, maybe paper. The other, you're maybe able to search. You may not be able to see if an invoice was paid prior to the time, by when it was on the other property manager system. So there's a lot of issues with, and that happens because, and I hate to say it, but property managers, they kind of know where they can get what they can get away with on that, and they will not turn those records over. Sometimes it's because they haven't been paid. And that is even, for a CPA, for example, that's not a legitimate reason. I cannot keep somebody's documents. Now, I don't have to give them the QuickBooks file. Nothing that says I have to give them that. I only have to give them what's theirs, but what's their records. But for example, if I'm entering into something and the contract says that if the contract is terminated, you have to give me your electronic file, that might put you in a little stronger ground so that at least you might say, okay, I'm going to pick somebody who uses Tops, or I'm going to pick somebody who uses QuickBooks or whatever, so that at least you've got a better chance of, even if you're going to get the electronic file and be able to convert it to something else instead of just having a bunch of paper that your only choice would be to re-enter all of the information, including bank account information and bank reconciliations and all that. So that's one of the things that is kind of a bone of contention in any of these deals. And there are different levels. Like Peter said, you've got the property managers have a code of ethics that they got to follow, but their code of ethics isn't the same as, for example, a CPA that's doing your bookkeeping, because in that situation, I have a responsibility, even if I haven't been paid, frankly, I have a responsibility to provide you with information that I may not have to do as a property manager. So,
well, actually, the manager code of the manager code of ethics also provides that that a manager cannot withhold just because there's a dispute over payment.
right.
So that's in there too. And by the way, lawyers, we don't have any ethics.
Yeah,
So
that's right. So he can keep everything.
We don't have ethics.
You got attorney-client privilege, which means you're the attorney, you get to keep everything. The client suffers. No, that's
Actually, that's somewhat true. I mean,
yeah,
the lawyer's file is their property.
Yeah.
But anyway, I'm not.
No,
yeah, but we don't have ethics for other reasons.
No, and well, and you do have a different, you have a different, your ethics, like we've talked about before. The ethics for attorneys comes from a little different viewpoint or standpoint than, say, a CPA's code of independent of ethics, which is based on independence, and being independent. And there's reasons for that versus, the way that the attorneys handle it. But the other thing that I'd kind of ask you about, Peter, and see if you've seen any language in contracts to this effect. But what used to be pretty prevalent in this area, at least, was that a property management company would want to get a job. They'd want to win a bid or whatever, and so usually the president would act as a gatekeeper, kind of like John talked about before. Maybe not solely picking the winner, but maybe picking who can be up to be the winner, which ones you're going to actually talk to. We all know I can pretty much pick, if I want 3 bids, I can pick 3 companies that I'll know for sure every time which one's going to win, because I know, some have horrible reputations. So I know that firm will get blown out right away when they check references. So all I have to do is check some references. And I know other ones that, are going to be way too high priced or have all kinds of hidden fees and things like that. So there's so that puts you in a situation where, you can kind of juggle all that. But what they were doing for a while, Peter, is that the property management firm, the bigger ones, would hire a board member to work on another property. In other words, the president would get a job working for the property management company, and they would be paid to work for the management company. In many cases, it wasn't necessarily a property manager position, so the person didn't have to have a license. Have you seen that dealt with in contracts at all? Any kind of prohibition on that?
You mean where a board member gets hired by the property management company?
Yeah, where there's a restriction on the hiring of a board member by the property management company.
No, I haven't. I mean, I've seen the restriction the other way, where the association cannot, hire cannot hire the property manager who's assigned to them,
right?
Without a lot of penalties. I haven't seen the other way, although I see where you're coming from. But I mean, there are restrictions where just in the law where a director cannot have a financial interest, but I guess that's a little different since they don't, that's more of a ownership interest than just being an employee. But no, I haven't seen that per se. It sort of reminds me of the college recruiting, where the great recruit, their father gets hired by the university as an assistant coach or something, and then the recruit goes to the school, right?
Yeah.
Because the father got hired to do something. You used to see that all the time. I guess you still do.
Yeah.
You're saying the same thing in essence.
Yeah.
Uh,
I grew up in Illinois, and Illinois basketball was the big sport, and that's we actually had
they're
that
good.
at the
They're
high
good
school.
right now. Anyway.
Yeah, no. We used to actually have that at the high school level. I actually my junior year, I think it was in high school.
The high school coach would get hired, right?
Well, no, yeah,
No?
that was going to college. So
Correct.
we had this kid years ago. He ended up playing it. He ended up going and ended up playing at Kansas, and they won a national championship. And I forget the kid's name, but he was really a tremendous basketball player. But he was out of inner city Chicago, right? So he's down in inner city Chicago. The teams down there, they had unbelievable talent, but it was a lot of times it was hard to get a scholarship out of there because a lot of the coaching wasn't always the best in the world. Now that's changed over the years, and but in those days you didn't always have the best coaching. You didn't have the best ability to get out. It was a lot of playground ball, that type of thing, a lot of one-on-one. But anyway, this kid, his dad got hired in Lincoln, Illinois. Now that's way in downstate. That's down past the middle of Illinois. He got hired by this company down there at a really good salary, so that he could go to Lincoln High School, become a Lincoln Rail Splitter. That's the name of the Lincoln team at the time, Rail Splitters. But anyway, he became he went with them, and of course they ended up winning the state championship. And then his high school coach ends up getting hired as the assistant coach at Kansas, so that the player ends up going on to play where where they wanted him to play. So it's kind of an interesting scenario, but it's hard to believe that stuff back. I mean, that was in the 70s. It's hard to believe that was happening even in the high school level, that they would do those kind of things and provide jobs for people to.
No, it's not.
And it's justified too. I mean, it's important to have a good high school basketball team. I know how important that is. So anyway, but anyway, so I think that, but we did see some contracts like that was happening up here for a while, a number of years ago. I haven't heard much about it lately, but it was real popular. There was one property management company up here that used to be pretty aggressive, and one of the ways that they would kind of get a leg up is they would offer the president or a board member a job on one of their other properties, and, so that at least they knew they had that vote and maybe another one. So
I just saw recently, I mean, this is kind of off topic, but since you're talking about property management companies, I mean, this group of attorneys that I belong to, and it's all community association lawyers and developer lawyers who draft these documents. There's a group that's all together on this Florida bar group. Anyway, one of them had posted the other day that there's and I'm not going to mention any names, but there's some management company out there that basically makes all the vendors pay the management company a fee. To work for that association of X dollars, I guess a year or whatever.
Yes,
it's like, it's crazy. It's I don't know.
I've seen it two ways.
Reminds me of I don't know, some kind of crime boss or something.
No, it is. I've been on the other side of that, and one of them is a big one. One of them is a relatively large firm, and what they do is they don't specifically they don't go to you and say, okay, you got to pay this fee, or we're not going to hire you, but you have to be one of their approved vendors.
Yeah, I've heard that too.
You have to go through this process, which usually involves spending some money to become an approved vendor, and which I always thought was kind of a crock. That was, but we had a property management company years ago up in Vero that what they sold was to the associations is that, look, we will provide all of your services, and because we control and provide so much of that service, we control all the contracts, and you'll get a 20 or 30% discount off of the normal prices. So you'll get the same vendors that you would get somewhere else, but we'll get you, because we control them all, because they're actually working for us, um, will, you'll get a big discount, and you couldn't break into that. So as a CPA, for example, uh, I was never given an opportunity to bid on any of their work. If you wanted to do their work, first of all, most of the time you couldn't get in. They had one CPA and one CPA only, which I thought was kind of lacked independence there. Talking about independence, how can when you're dependent upon and their fees at the time, the audit fees were around $3,400 is where the audit fees were at that time, and these guys were, and the CPA firm that was doing the audits were charging 2,500, um, and that's and so now the question is what kind of service are you really getting, what kind of, and what's the chances that one of those vendors is going to turn on the property management company and report them, and so it was a big issue. I'm surprised to some degree that it's still going on, but they had all kinds of ways, and we we stopped using one of the larger firms down south, one of the large property management firms down south, because we felt it was kind of unethical. The way they were doing the screening process on the vendors. It was potentially putting us in a position that we felt like our independence was being threatened, and we were having a hard time figuring out how. But some of the other CPA firms down south, they had no problem with it. They were signing up, paying the fees, and drinking the Kool-Aid. So it's amazing what's going on. But so that what did your group decide? Are they pursuing that kind of thing, or what are they going to do? Or that was just informational?
No, most of the comments were just, this is pretty ridiculous, and blah blah blah.
Mhm.
I mean, so I'm not sure what's going to happen, but I just mentioned it because I thought it was I'm not sure. I mean, I'm obviously that's not something that any company, in my opinion, should be doing.
Yeah, no, I agree. It's kind of, I mean, it's one thing to advocate for your properties and try to get the best service possible and the best vendors. And I do know that it's a tough situation because there's kind of a give and take. There's certain vendors out there, and there's only a handful of them or less that are really any good, and everybody's clamoring for them. Everybody's trying to get them. And so if you're a property manager, you're probably you're probably cutting them some you're probably trying to keep them happy, so that they'll continue to do your properties versus some other property manager's properties. And so there's a lot of that out there. And then on the other side of that, you've got certain vendors that we've had trouble with that for years in the industry. Is the president of the association's getting their lawn mowed by the same company that's doing the association. Lo and behold, they're not paying anything for it. That kind of thing.
Well, yeah, I mean, but at least we have statutes on that.
Yeah.
But no improper benefit, unjust enrichment.
It is very hard to find those, though. As an auditor, it's almost, it's very difficult to find that, because you go to the vendor and you get a vendor that you suspect that that's the case, but you can't, the vendor's not going to turn them in.
They're not going to tell you that they're cutting the president's yard for nothing.
Right. And in fact, they probably, they probably aren't doing it for nothing, because that would be pretty much obvious. But, if you're doing it for half what the normal price would be, or
whatever.
Yeah, right. So then it's pretty hard, because that's just a case by case situation, right? Everybody's property is a little different. So I don't know. It is an issue that's still out there. And I know property managers have to deal with it. Plus, a lot of times the property managers, they want to find out, the property managers want to find out whether these guys are going to do the job. You don't want to sometimes risk them on your biggest property, and find out later they can't do it. So, you test them out on a small property or on something else, or get somebody that's used them, that type of thing. But so it's very difficult. I think it's an area that there's a lot of potential abuse. I think years ago, Peter, that was the client that you and I first met on. I think that the issue that came up is they had a bunch of these big palm trees, and they did a huge amount of landscape renewal, and all the palm trees were gone. And of course, they had a new board that had come in versus the old board. And they threw out the property manager, but and then the property manager sued. But anyway, the whole thing was that we were told that that what happened to all those palm trees? Who got the proceeds from those palm trees? And we actually confirmed with the landscape company, to try to find out that there was no money that changed hands. It didn't go to the property manager and all of that kind of thing. But if the landscape company is taking those palm trees out and selling them on the side, not reporting them themselves, what's the chances they're going to send you back a letter saying, yeah, we sold those and split up with the property manager, And so it's almost impossible to find that kind of stuff. You really can't, because there's no documentation of it. Stuff just disappears, and there's no way to find out what happened to it. Oh, it got thrown away. Well, okay, that was stupid, because those were worth about 10 grand a piece, but it got thrown away. So anyway, it's always an interesting process in what we do. So it's kind of a fun thing. We're running out of time this morning, but appreciate the calls. John, appreciate the call. For those of you out there that are kind of new to the show, we're here every Monday from 9 to 10 o'clock, and we're here just to answer your questions, to provide you with information, deal with issues. We try to provide advice when there's no questions. We try to provide some advice, talk about some issues that are out there, things that you might need to be aware of, and things that might help you have a better association. Because all in all, these associations are all yours. You share, you're in this communal environment, and you're agreeing to share your neighborhood with others. And so it's very important that you get along. It's not like a corporation where you can leave work at night and you're gone. I leave and go home. This is where you live, so it's important. And so if you've got some stuff going on and you got questions, you're new to condos or HOAs, give us a call. Call us. Write the number down, 220-9788, 220-WSTU. Keep it for next week. And feel free to call. We'll be here for you right here on WSTU Digital 1450. We are Martin County's Heritage Station.